Supreme Court has formulated few guidelines based on its suggestion. And then there is also prison reforms. In that case, also SAR has acted as amicus. So since this practice, even till now, SAR has been an asset to the Supreme Court of India, and he has been a friend, and he's also very dear to our association. And when we asked him for a lecture, he's immediately said okay, and he's agreed, and he have made a lot of efforts to give this lecture. And sure, now I hand over the session to you. Please go ahead.
Thank you, everybody. So I have 10 cases I need to deal with. What I intend to do is to take about 3 to 4 minutes in each of the cases, and then I have prepared a 1 page or 1.5 page note in each of these cases, so that when you go for the exam 1 day prior to the exam, you can revise those cases. When we took the exam in 2005, I think we had only about 35 to 40 cases. So it was simpler. Now I understand there are more than 60 cases. So it was impossible to remember all those cases. What you need to do before the exam is to quickly revise, make a 1 page note of the important points. For my cases, I have done that. You can add to it or you can change it. It will be given in a Word document after this meeting, so that you can make and quickly revise. So the first case we have today is IR Coelho versus State of Tamil Nadu, 2007 2 SCC page 1. This case arose it's a 9-judge bench decision. Very important case for you to recollect in your career as law, but only if it concerns the constitution. So what happened in this case was that Parliament enacted Article 31B of the Constitution, where large number of central as well as state laws were being put in the 9th schedule of the Constitution, the effect of which was that they were immune from challenge on the ground that they violated the fundamental rights. The question arose before the 9 judges was that how long can you permit this, and to what extent are you going to permit Parliament to simply take laws and put it in the 9th schedule, and then if they put it in the 9th schedule, they will be immune from challenge on the ground that they violated fundamental right. The consequence of this would be that your fundamental rights would stand abrogated completely by an indirect method. So the Supreme Court in 9 judges actually was called upon to decide what is the limit of judicial review of laws which are put in 9th schedule. So that was the first question which arose for consideration. So if you ask what is the question of law which was referred to 9 judges, the first question was what was the extent of judicial review of these laws which are put in 9th schedule. Second and most important question of law was, suppose a High Court or Supreme Court strikes down a law. For example, in this case, the Tamil Nadu law is struck down, and thereafter the Parliament puts it in the 9th schedule. Can you do that? In the sense, because the law has been already struck down. So can Parliament put a struck down law in the 9th schedule? The answers to both the questions were succinctly stated is as follows. Number 1, as far as those laws which are put in the 9th schedule of the Constitution, it is open for the court to examine the said laws and declare them unconstitutional only if those laws violate basic structure of the Constitution. That is because by incorporating those laws in the Constitution, they become a part of the Constitution, and therefore they cannot be struck down on other grounds apart from basic structure. So that's a very important thing which you remember. Whenever you want to challenge the law which is in 9th schedule, you will have a higher threshold. Secondly, the court held that even if a law is struck down by the High Court or the Supreme Court, it can be inserted in the 9th schedule, but still it will be open to challenge on the grounds of violation of basic structure. Now, this judgment is a 9-judge bench judgment. To my recollection and my research, I do not see a follow-up of this judgment where this judgment has been applied and followed. But if the question comes in the exam, you'll probably need to examine how this judgment has been followed subsequently. So my 1-page note will help you only to capture whatever I have told you orally right now. It is captured in 5 points in my note, which I'll send it to you after this meeting. So then I'll take questions at the end on all